Hi, it's Carla with Murlac Tax, and I'm here with Stacy Stusowski, who is an estate planning attorney with her office in Crystal Lake. We will be discussing the basics of wills, trusts, and powers of attorney. I chose this topic because over half of the people I meet with do not have their end-of-life documents in place. In fact, a survey conducted by Caring.com surprisingly found that only 4 in 10 Americans have a will or a living trust, although older adults are more prepared than younger adults. And why is that? Most people don't want to think about death. They may feel it's too expensive, or that they don't even have enough assets to worry about it. Stacy, could you give us a brief description of a beneficiary and why that's important?
Absolutely. So beneficiary designations are available on many types of accounts and things like life insurance policies. They're one of the key things that you want to set up when you have things like 401ks, IRAs, whether it's whole life or term life. Having those beneficiary designations set up correctly is important to make sure those assets don't go through probate. They're a built-in probate avoidance tool for many people, whereas if you don't set it up, I've seen that the default in most cases is to the estate of John Doe, and that turns this wonderful probate avoidance account into a probated asset. So it's definitely important to set those up.
Perfect. And I've seen on a tax basis too, then that creates havoc with the taxes.
Absolutely.
So I just recently did a video on the importance of a beneficiary review, so I hope that you were able to receive that and take a look at that. Let's move on to a will. What is a will? How does that work?
So a will is a testamentary document, and it's a good cornerstone document for setting up what your wishes are if something should happen to you. There's a common misconception that a will allows you to avoid probate. That's actually untrue. While a will is important, it can direct how probate should go. It doesn't avoid probate itself. That being said, it is still important, especially if you have minor children, because that's how you set up things like guardian provisions. You can designate an executor and determine who should get the assets that aren't covered by things like beneficiary designations.
So even a younger couple, if they have a child, that's something that would help them make sure that their child's taken care of.
Absolutely, because that's where you can put in guardianship wishes. If something unexpected happens to you or your spouse or the child's other parent, then having that guardianship clause in a will is essential to ensure the child goes to someone who is able to take care of the child. They're young enough to take care of the child, they have the financial resources to do so, and that would all be designated in a will.
Oh, okay, great. How about moving on to a trust?
So trusts there's a broad range of trusts available, but the most basic one that's out there is what's called a revocable living trust. And for certain people, a trust can be an excellent probate avoidance tool. So we talked about beneficiaries being probate avoidance tools. Trusts can provide additional comprehensive probate avoidance planning because they can hold things that might not be covered by beneficiary designations, such as real estate, business entities, certain other types of perhaps brokerage accounts, savings bonds. So if a client has enough significant assets, that's where we can look at trust planning as a way of kind of consolidating the beneficiary and heir designations to make those sorts of things more centrally manageable for the client.
Perfect. We'll come back to that because I had another question about that.
Sure.
But what about the powers of attorney?
So powers of attorney documents, there's 2 types in Illinois. There's powers of attorney for health care or medical power of attorney, and then powers of attorney for property or financial power of attorney. And these documents, quite simply but very importantly, set up people who should be in charge if ever you're incapacitated. So whereas wills and trusts might be death time planning documents, powers of attorney are planning for life, what if you live, but you're not able to take care of yourself. And that can put people in charge that you want, as opposed to leaving it up to fate or who's the loudest person in the room.
Perfect. Thanks for the clarification. Now let's start by just talking about a young couple, family. Would they need a will?
So usually wills come into play, if you have just enough assets that you're worried about where they're going, and then particularly if they have minor or young children, making sure that they have guardianship set up. So it is very important for them to have a will in those types of instances where maybe it doesn't avoid probate, but at least it clarifies their wishes about who should get those significant assets, like the car or the savings account that they've started, that sort of thing. And making sure, either grandma and grandpa or aunt and uncle can take over caring for the children that are left behind if something unexpected happens. But more and more with younger folks, even if they don't have children, perhaps a will isn't as important, but powers of attorney, I think, are extremely important for people who are over the age of 18, because then otherwise a guardianship case in the courts would become necessary to set up who's going to be the medical or financial decision maker. So if you want control of that and you want to avoid guardianship, then by age 18 you definitely should have powers of attorney set up at the very least to protect yourself in case you become disabled.
So starting at a very young age.
Absolutely. Absolutely.
So now we continue on our life journey. We're, say, 40 to 60 years old. It gets a little more complicated because we may be married, we may be divorced, we might be remarried, hopefully have more assets, and you could be getting an inheritance from your parents. So Stacy, could you touch on where the will or trust comes into play?
Absolutely. Well, if the young couple went and did the basic documents, then they were very covered when they were younger. But then as their assets grow, that's when we do need to start looking more at probate avoidance strategies, such as ensuring those beneficiaries are up to date and setting up the trust documents for people whose situations call for that sort of thing. So evaluating your strategy as your assets grow and your circumstances change is important. But then particularly with blended families, you can get into a lot of different complexities as far as his assets, her assets, our assets, where you want things to go if you have children from the prior spouse or prior relationship, protecting their inheritance, but also making sure your new spouse is taken care of. So those are all very important things that you should evaluate and discuss now versus later when it's too late to say what it is you want to happen.
And that's so often the case when I meet with people and their concerns to make sure that their new spouse is taken care of, but children from a previous marriage still will have some benefit to the assets that they've accumulated. So that's very important. And then we briefly discussed the powers of attorney and how important that is. I think a lot of people, they may have gone to the emergency room or needed surgery, and the hospital does ask, do you have your power of attorney?
Absolutely.
So having that document when you're in a relaxed, conscious state of mind and not in a panic or maybe not even able to make that decision is very critical.
Absolutely. Yes, setting that up with an attorney versus, when you're under the gun is often a better idea.
And letting somebody you trust know where the documents are is important too. So now, by age 60, somebody has their will, their trust, their powers of attorney in order. But how often do you recommend that that's reviewed or updated, or what would cause a need for that?
Well, I do recommend getting a checkup perhaps once every 5 years or so, just to see if there were changes in law that might have affected things, such as an increase or decrease in tax exemptions, an increase or decrease in the probate threshold in Illinois. Currently it's $100,000, but that could go up or down depending on the legislature. So that by default is just a good idea to see what has changed. But then when certain life events happen, divorce, remarriage, the birth of a child, those sorts of things, then it can be important to reevaluate what your wishes are. Or some people have family conflicts that arise that causes them to have a change of heart or a change of mind. So those sorts of things could also be affecting your peace of mind as well and should be evaluated. As people get older, their situations tend to stabilize a bit. Their assets aren't growing as much. When their assets have kind of reached that critical mass sort of thing, then that might be less of concern. But evaluating things if a child should, God forbid, pass away, or if they're looking to benefit grandchildren, perhaps setting up a college fund, that sort of thing, then strategic giving and strategic gifting can become an important discussion to have too.
Yes, and charitable giving.
Absolutely.
That's something that can change through your life.
Absolutely.
So that's great. So on a normal basis, 5 years.
Yes.
I meet with people that drew up their documents in 1989.
Oh, yeah.
And have never had them reviewed.
Yes.
And I think that's critical.
Absolutely. And sometimes those older documents are set up correctly and appropriately, and maybe just need a little bit of fine tuning or some additional detail. And sometimes we find that the documents are a bit outdated. I've even been told that certain banks and things like that won't accept an older power of attorney for property and want something that was done within the last 5 to 10 years. So that's something to even just ask your banks about. Hi, would you accept this document if needed? So,
very true.
Checking on those kinds of things can be helpful just from a logistical planning standpoint, let alone peace of mind.
Okay. So, Stacy, could you explain the process when somebody wants to move forward, take the next step?
Absolutely. Well, I sit down with my clients and do an initial consultation where I just get a feel for what their situation is. And some clients just want to come in and ask questions first and kind of, there's a lot of personal information that I need, so I want them to feel comfortable with me. So if that just means sitting down and answering questions at the first go around, that's perfectly fine. I work at their pace. But what I do like to do is try to get a general overview of their situation, because then I can make fine-tuned, custom-tailored recommendations for what I see for their situation. I don't want to be lecturing somebody about trusts if all they need is a transfer on death instrument. They don't need a law school education.
Yes.
So we will have a discussion that's as tailored as possible to their circumstances. And first I like to get an overview of the family dynamics, who's important to you, what's important to you, are there any things like supplemental needs or special needs planning we need to consider. Personal and religious beliefs can often play into these types of documents too. So getting those preferences and things like that detailed first is important. And then we go into the financial discussion so that I can give them insights on, well, here's where I see some tax risks if they're over any estate tax thresholds, or here's where I see that we need to do some probate avoidance planning so things don't end up having to go through the court system if something happens to them as well.
And at that point, you would make your recommendation.
Absolutely.
Allowing them to choose what they're most comfortable with. And then pricing is discussed at that time.
Yes.
And I think it's much more affordable than people think.
Yes.
So if we were talking the very basic will, young person starting out, they had maybe a little IRA or 401k, not owning any property, but they had a child and they wanted to make sure that their child's taken care of. What range are we talking about for that?
Yeah, so for that sort of situation, usually the flat fee that I would charge for the document package of a will, powers of attorney, would be $700.
Yeah, so reasonable.
Absolutely, especially for a married couple, for documents for 2 people,
Right.
Absolutely.
And then if we move into the 60-year-old couple, that's a blended family.
Mm-hmm.
Simple assets, beneficiaries, but they have 2 properties and kids from each marriage, and maybe a trust is more appropriate. What is the range on the trust? Where does that start?
So the revocable living trust planning starts at $1,600, and that's where we can get into things such as blended family type planning, multiple pieces of real estate, and perhaps even some out-of-state property.
Okay.
For people without blended families, that perhaps they do have that piece of real estate and an IRA sort of situation, and maybe they do have a long-term marriage, they haven't been divorced, that's where we can look at some alternative options between $850 to $1,200. So there's a range that kind of, everybody falls into somewhere within those ranges.
So you can see it really is cost efficient and to have that peace of mind. So I encourage everybody, to take that next step. Don't be concerned about thinking that death is imminent because you met to discuss this with an attorney. You wake up every day thinking, what if I didn't come home today? What would happen? Just that peace of mind will free you of that burden. So Stacy is one of the attorneys that I work with. In addition, there are several other estate planning attorneys, and I'm here to guide you to the best one suited for your situation and location. By starting with me, reviewing your values, your dreams, your goals, and questions, we can review the beneficiaries on your accounts, make sure they're up to date, and afterward, I would put you in touch with the attorney best suited for your situation. Of course, you can reach out to Stacy if you have any specific questions for her at 815-893-0043. Thanks again, Stacy, for joining me today.
Thank you.